A lot of important legal battles are fought before a trial ever begins, and that is what is playing out in the case of the father of the Oxford school shooter, facing the same 4 counts of involuntary manslaughter his wife Jennifer faced and was convicted of earlier this month. James Crumbly's defense attorney wants an entirely different outcome for her client, of course, and she is showering the court with motion after motion right now to try to keep some evidence out and other evidence in this case. With more on what she's asking for, Rod Maloney, who sat in on today's first major motions hearing. Rod.
Yeah, Devin, it's been busy out here. In the last couple of hours, the judge granted a motion by Maria Lehman, who was James Crumbly's defense attorney, asking for more preemptory challenges. That means that when they go to panel the jury, that they can actually exclude more people if they don't like the answers they're getting. The judge said yes to that. They want to change the venue. There was this file last night to keep the shooter's journal and text messages out of the case. And then we had the hearing this morning, which talked about the exclusion of still more evidence. Assistant Prosecutor Mark Keast told the judge why he's asking for 2 former students to testify.
But they saw a student dressed in all in black. RF saw the gun raised. She saw what she thought was an orange tip. Turns out it was actually the muzzle flash of the firearm as it was fired at her. At her. Correct. Both were wounded, both survived, obviously.
Maria Lehman's concerned, since the judge already approved showing the security video to jurors without audio, that the students' stories will inflame their emotions.
When it comes to these 2 students, their testimony, even if the court finds it relevant, is unfairly prejudicial to James Crumbly.
Judge Matthews said she'd rule on this corner of the case soon. Meantime, the shooter has an appeals attorney who will not allow him to testify in his father's case, prompting her to file another motion looking to exclude the shooter's journal and text messages and other mental health information, stating, quote, admitting evidence without Mr. Crumbly having the opportunity to cross-examine the writer violates his constitutional rights to due process. If the court is inclined to allow portions of the journal pursuant to a prior ruling, texts between the shooter and his friend, and texts between the shooter and his mother, despite there being no evidence that Mr. Crumbly was aware of any of them, then the court must also allow the defense to cross-examine witnesses with information learned from the protected records, end quote. The protected records come from the shooter's appeal. They've essentially closed off that information, and so the defense wants to get at that. In the meantime, there's going to be hearing on that question, the change of venue and other information, or other issues rather, coming up on the 28th of February. Reporting live from Pontiac, Rod Maloney, Local 4.
All right, Rod, we will keep following all of this. As this trial carries out, you're going to see every minute of it as we stream the proceedings live on Local 4 Plus. We'll also have exclusive analysis and daily recaps of everything that happens. The trial is set to get underway March 5th.